Thank you for tuning in on another episode on the Scouse Oracle channel. I truly appreciate it. Around 85% of you are loving the content and keep coming back who haven't yet subscribed. So if you can, it would be a massive help. Today, I do want to deep dive into the Epstein files. I have spent time going through the documented evidence, the court cases, the patterns across the institutions, and what the government is now legally required to release under the Transparency Act, because for me, this is about systems, not speculation. The truth is always bigger than one man, and I know that there's a lot of speculation out there. There's a lot of noise surrounding it, especially with coming up to mid-December, what we should be expecting. So I have done a full breakdown, a timeline, and hoping to provide you with more clarity. And I also go into the reason and the psychology in behind why I believe this is important in today's climate. Now, the early warning signs, because the system seen the smoke long before it admitted that there was a fire. I think we can all agree on that. In the mid-2000s, Palm Beach police received multiple reports about Epstein abusing underage girls. Girls described a consistent pattern of money, promises, pressure, being encouraged to bring others, and this was happening in plain sight, supported by adults who enabled the behaviour. Now, when you hear me talking about this, I have listed a full sources in the caption, so you can go, and this is all documented. This is all within the court cases. I have also provided a free educational booklet, which is in my link, and you can download that for free. There's no speculation, it's just a current timeline, and it's got everything in place for you, all in one place, because I feel as though when things are scattered, that's not clarity. In the 2007 to 2008, we had the non-prosecution deal. So federal prosecutors secretly negotiated a non-prosecution agreement, and victims weren't told, which violated their rights. The DOJ later confirmed survivors were kept in the dark. So this deal shut down the federal investigation and then shaped the next decade. So right there you can see what happened. In 2019, it was then that prosecutors reopened the case in New York, and then we had the charges of sex trafficking and conspiracy. Multiple survivors gave consistent accounts across years. Epstein died before the trial, meaning that the full evidence was never laid out in court. So then we had the Maxwell trial, the only full trial that we've had. So with Epstein gone, Maxwell's trial became the only complete record. So it was a jury that determined she'd actively recruited, groomed, transported and facilitated the abuse of minors. And then you had the appeals court and Supreme Court who upheld this conviction. And when you follow the money, the bank cases, so the trafficking relied on financial systems. JPMorgan and Deutsche Bank were accused of ignoring red flags. Now, accused of ignoring red flags and enabling Epstein financially. So the USVI had a settlement of $75 million. We had the survivor settlement of $290 million. And these institutions settled instead of risking what would come out in court. So bear that in mind. So then we move on to the civil cases which were revealed, which was the unsealing of the documents. So the civil cases revealed the recruitment methods, that the house staff involvement, the property movements, the flight patterns, and then the consistent survivor accounts. So these documents exposed the structure of the operation. So what the Department of Justice, the DOJ, and the FBI files have shown already is old investigative material heavily redacted FBI notes, Epstein evidence that he provided information to the FBI back in 2008, and internal memos. So the public has only got fragments. The government has the full picture. Now, the Transparency Act requires the Department of Justice to release all unclassified Epstein documents within 30 days. So this is what would include the memos, the emails, the closed case materials, and the investigative records. What it doesn't include is classified documents, active investigations, grand jury material, victim identities, and uncharged names. So what you need to look out for in December is you need to look for the patterns. You don't look for the centralisation. You look for which investigations were quietly closed, and this is what I'll be looking for. And when they do come out in December, give me a while, I'll be bringing you a full breakdown. Which warnings were ignored? I'll be looking at how quickly agencies backed off, contradictions between internal memos and public statements, evidence trails that stopped abruptly, and institutional delays, hesitations, and blind spots. You see, why I don't name people and why you shouldn't be naming people, because naming uncharged individuals not only spreads misinformation, it re-traumatises survivors, and it derails accountability. And survivors consistently say online, speculation harms them. Now, when these files drop, stay grounded, because people online will want to push narratives, screenshots, emotional bait. But for me, and I hope for what I continue to show my followers, my community, is the truth is always in the patterns, the documents, the institutional behaviour. And that's how you honour survivors. You hold the systems accountable. You see, online emotional hijack is a perfect environment for manipulation. When information is incomplete, the mind desperately wants certainty, and that's the moment when narratives, true or false, they become very seductive. You see, being emotionally neutral keeps you away from being stirred by tone, confidence, fear, and it allows you, it definitely allows me to interpret documents as they are, not as someone who's telling you how to feel about that document. And that's in everyday life, emotional intelligence. You see, when these documents arrive in December, people are immediately posting screenshots, heavy redactions. One person's going to say, well, this proves everything. Another's going to say proves a global conspiracy. Someone else will say that it proves that the whole thing is pointless. But all of that ignores the simple truth in that some redactions are mandatory to protect victims, witnesses, and ongoing investigations. And that in that moment, the manipulation isn't in the document, it's in the framing. So in the Transparency Act vote, which I found very interesting, when one person voted no, because the Epstein File Transparency Act passed the US House with a 427-1. So that single no came from Representative Thomas Massie. So understanding his reasoning is important because it shows the difference. People can cloud judgment on that no vote. You see, there's opposing transparency in itself, and then there's opposing the method that's being used to force it. So according to his public explanation, Massie did not vote no because he wanted the secrecy around it. He voted no because the act used congressional authority to compel the executive branch to release specific documents. So basically, his argument was separation of powers. He believed that Congress ordering the Department of Justice to publish investigative files set a precedent that could weaken boundaries between branches of government. Future implications, he argued that in Congress can force the DOJ to release files today. A future Congress could misuse the same power to force the release of sensitive information for political purposes. So that's the legal framework around it. And one can see where that makes sense. You can understand his reasoning. But there's a fine line, because he stated that the Freedom of Information Act already exists as a legal mechanism for requesting government documents. His concern was Congress overriding existing law rather than reforming it. So whether people agree or disagree with his reasoning, the important point is his objection was structure, not personal. It was about the mechanism, not the material. So this is why understanding systemic thinking matters, because not all disagreements are rooted in motive. Some are rooted in constitutional interpretation. And for me, personally, my view, I know from the Freedom of Information requests that I have been receiving how there also can be a lack of transparency. So there are questions. So when the file drops, I know that, and you know, a wave of narratives will hit the internet instantly. You know, some will be helpful, many won't be helpful. And my advice would be to, and definitely what I'm going to do, is to be staying grounded, notice emotional reactions before accepting someone's interpretation, focus on documents, focus on the documented behaviour, not dramatic claims. And remember that institutions reveal themselves through patterns, not headlines. Keep your attention on systemic failures, not speculation about individuals, and stay aware of attempts to steer your feelings rather than your thinking, because the strongest position is a calm mind reading primary sources. And I will be here to do a full debrief. There's always a stone to be unturned. There's always a situation that will need clarity, and I hope that I am the person providing that for you on this platform, and I will continue to do so. I appreciate all your support. I am waiting for some responses back this week as well from the Department of Education regarding the unique identifier for children. As I say, there's always a stone to be unturned. There's always questions to be asked. There's no silly questions. And I'll be bringing it all to you. Thank you for tuning in, and I shall see you soon.